All right, and we are live, and this meeting is being recorded. So I'll hand it over to you, Danielle, for the announcements.
Sure. Welcome, committee members, liaisons, and members of the public to the Legal Services Trust Fund Commission Homelessness Prevention Committee meeting. Thank you for joining us. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please type "I have a comment" or "I have a question" in the chat, and a message will be sent to the host. Alternatively, you can use the raise hand feature. In efforts of transparency for those joining this public meeting, whether by phone or by Zoom, we request that you refrain from having side conversations on chat about the content of the meeting. Again, the chat feature is utilized simply as a tool for you to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. Please note all Trust Fund Commission and committee meetings will be recorded and posted to the State Bar website. And a friendly reminder that this is a video conference and to please be aware of your surroundings behind you. Thank you.
Thank you very much, Danielle. Christian, would be okay if I started with roll?
Yes, please do. Thanks everybody for being here. Take it away, Chris.
All right, Christian.
Here.
Bonachet. Amin.
Here.
Herman.
Here.
Eric.
Here.
Jim.
Here.
Rich.
Here.
And Kim Savage.
Here.
Wonderful, thank you. So we do have quorum. And I will also ask about our liaisons. Selena Copeland. I see you waving. Hi, Selena.
Present.
Bonnie Huff.
I'm present.
Christine, be a Board of Trustees liaison. And then Mark Toney from the Board of Trustees. All right. And then State Bar staff, Dwan Nguyen.
Here.
Dwan, Chris McConkey, Danielle McRae.
Here.
Brady Dewar. Okay, and I see we also have Dan Pessimenic. Hi, Dan. And are there any other State Bar staff members? All right, and then I think we have a few other representatives from liaison organizations. So I see Lauren Klein. Hi, Lauren.
Hi.
And have I missed anybody who's a liaison?
Sure.
Oh, Kim Wormsley, of course.
Oh, no. There's a few attendees. There's someone calling in on the phone. I'm not sure who that is. There's an Annie Chin and a William.
Great, thank you. And then of course, I'm sorry, Kim Wormsley, I also forgot to note that you were a staff member. So thank you for joining us. All right, we have a quorum, Christian.
Great. Are there any members of the public that would like to identify themselves at this time? Okay. Well, believe it or not, my computer has frozen, so I cannot pull up the agenda until it unfreezes. So Chris, I know today we're going through a slide deck about the scoring rubric, and I'm going to hand it off to you to Antoine to sort of go through the various slides for the committee. And I can start that now, but I'm not sure if there's an item.
We had one other agenda item, which was the approval of the meeting minutes from July 30th, 2021.
I was just going to ask. So hopefully people had a chance to take a look at that. We did have an intervening commission meeting after our last committee meeting, but I will entertain a motion to approve the minutes.
So moved. Second.
So Rich moving and Eric seconding.
Thank you, gentlemen. Well, let's take roll on that.
Christian.
Yes.
Bonachet is absent. Amin.
Yes.
Herman.
Yes.
Eric.
Yes.
Jim.
Yes.
Richard.
Yes.
And Kim Savage.
Yes.
Motion passes.
Hey, Chris, can I ask a question? So
Are all the commissioners who are here members of this committee?
Let's see.
1, 2, 3, 4, 5.
Yes.
All right. So my invitation, which was roundly trashed by Bob Planthold to the commission at large to attend, I guess did not attract any takers. So that's fine.
Actually, there's some members of the public. I'm not sure if any of them are commissioners. And the other, Bonnie Shea is having a hard time getting on the link. So I don't know if she's in the waiting room, but I can resend her the link.
And I think William indicated he is on the phone.
Oh, okay.
Although we were, I thought, warned about unintentionally creating a commission meeting through the committee. So I think members of the public who are commission members who are here as member of the public are actually advised not to participate as commissioners for that reason, if I'm not mistaken. So
that was my recollection as well from Brady's. That was like Brady's opinion at the commission meeting on the 13th.
Yeah. Okay, well, we have a short agenda today, which is now back up in front of me, which is to discuss and approve the scoring rubric and the other selection criteria for the homelessness prevention, the competitive grants for the homelessness prevention money. And we have a presentation, PowerPoint presentation from Chris and Juan, and I'm going to hand it off to them to go through, and we can sort of talk along the way, or if you have any questions, just so indicate in the chat. All right.
And would it be your preference, Christian, to do public comment on this particular agenda item before Steph's presentation, or just following the presentation, or?
I think we can do it as the presentation is made. I think it's just more useful because, yeah, that would be my preference.
And then, so echoing Danielle's, maybe for members of the public who joined after she made our housekeeping remarks, if you wish to make a public comment during the presentation, please use your raise hand feature on the toolbar at the bottom of your screen so that staff can give you permission to, well, so that the chair or staff can announce that you have a public comment and then eventually give you permission to speak.
And Chris and Christian, Bonachet is now joined for roll call purposes. We can log her.
Great.
Wonderful. Thank you. Welcome, Bonachet.
Right. Thank you.
Okay. Just give me one moment to share my screen. All right. Again, you can see the slides just to be sure. That looks like it. All right. So good afternoon, everyone. My name is Chris McConkey. I'm a senior program analyst in the Office of Access and Inclusion and coordinator for the Homelessness Prevention Funds Committee. And I'm also joined by several of my colleagues, including Danielle McRae, Dan Pesmenic, and Duan Nguyen, who will probably be assisting me with this presentation. So staff's report to precede the committee's discussion will cover very, very quickly just a quick refresher of Assembly Bill 164 with a focus on the permissible activities for Homelessness Prevention 3 competitive grant funding, the timeline for competitive grants, and then for the substance of staff's report, the proposed scoring rubric, recommended updates to the request for proposals and scoring rubric that post date the posted committee materials, just feedback that staff received since the materials were posted 1 week ago. The application for the competitive awards, reporting requirements, other considerations, and then a proposed resolution for the committee's consideration at the end of the meeting. So I think I have just 1 or 2 slides on Assembly Bill 164 because we've covered it in some detail by this in the last couple of meetings. But as a reminder, and for members of the public, it allocates $40 million this year's State Budget Act to the Judicial Council of California to distribute through the Legal Services Trust Fund Commission for homelessness prevention grants. Regarding the amount of funding, the Department of Finance has confirmed that an additional $40 million will become available in the next 2 years, so that the next 1 to 2 state budget acts. And so the Legal Services Trust Fund Commission has already voted to make 3-year awards using the entire expected $80 million. And that is to facilitate efficiency in grant making, but more so the ability of programs to plan and staff long-term projects rather than having to staff and plan 1-year projects to be able to do a single 3-year project. It funds qualified legal services projects and qualified support centers to provide homelessness prevention legal aid. And that can include subgrants to non-IOLTA providers, including government programs. The statute provides up to 2.5% for administrative costs, and then the 25% of the remainder is for, which is up to $19,500,000 over 3 years, for the competitive awards, which are the topic of today's meeting. And a refresher on the permissible activities, since it heavily influences the categories in the scoring rubric. The statute provides that these grants for these competitive grants are to fund eviction defense, this is quoted from the statute, other tenant defense assistance in landlord-tenant rental disputes, or services to prevent foreclosure for homeowners. And then it goes on to list that, what legal services looks like. So pre-eviction and eviction legal services, counseling, advice and consultation, mediation training, renter education representation. Additionally, it's to provide grants for legal services to improve habitability, increasing affordable housing, ensuring receipt of eligible income or benefits to improve housing stability, legal help for persons displaced because of domestic violence, and the kind of catch-all clause, homelessness prevention. The grants may not supplant existing resources for applicants, and they may not pay for legislative lobbying.
What do we think bullets 2 and 3 mean? Legal services to improve habitability and increasing of affordable housing, if it doesn't include lobbying. Does anybody have I'm not immediately seeing what that means, other than eviction defense.
For example, an affirmative code enforcement action would improve habitability.
Oh,
Kim has her hand raised. Kim has practiced in this area. Kim, you're on mute.
Dan basically answered the question. Eric, it would be an affirmative habitability suit, usually for injunctive relief to get a property up to code. Increasing affordable housing could be non-lobbying or legislative work, could be working with housing associations, public housing associations, to increase the number of vouchers. That's just one example. It could be working with private developers to enter into partnerships to develop more affordable housing. Those are just a few things. People might want to chime in with more if they want. And
correct me if this is wrong, Dwan, but I heard that the feedback from the legislature for Homelessness Prevention 2 awards, which are the 2021 through 2023 grants, the feedback that staff received was, while legislative lobbying was out of bounds, advocacy towards administrative agencies was allowed. So
yeah,
like regulatory.
I believe that's correct. Yeah.
And just to echo Kim's last example, that's what I hear a lot of too, is a lot of organizations are working with private developers in order to increase affordable housing there. And it may be a little bit of feel good for the private developers to figure out what they need to be able to do for the good reputation in the community, but I've heard a fair amount of that as well.
That last point that Dwan mentioned about administrative, I mean, it could be also working directly with HUD and California's Housing and Community Development Department.
Thank you so much, Selena, Kim, and everyone else who weighed in. All right. So the slides following this one is sort of the end of the refresher, but just to remind the committee members and let the public know, the commission approved a timeline for distributing these awards at the commission's meeting on August 13th. So this is the approved timeline. The RFP application would go online for programs tomorrow, September 1st, and be due back a month later. The goal would be to have the grant begin by January 1st of 2022. So I'm going to caveat the slide, and I'm also going to invite Dwan and others to provide some background information here, but staff has received a request to allow for a convening in September for programs to discuss potential subgrant relationships and other partnerships. And staff has found that if we do that, it would be it may be necessary for programs to have an additional 2 to 3 weeks to submit their application to meaningfully design a subgrant relationship. So that would require pushing back all the dates by about 2 to 3 weeks. And staff finds that it would still be possible to do a January 1 start date, provided that the committee and commission be willing to meet in early December to finalize the awards instead of late November. So my next slide is going to show a proposed...
Before you jump to the next slide, Chris, let me give the background. Let me give the background before you jump to the next slide. When we, after we went and posted the memo with the scoring rubric, last week, the legislature reached out to the state bar to see whether it was feasible for the state bar and the commission to replace the requirements of AB 164 with the requirements of AB 1487. As you recall, that was the other pending legislation that would fund homelessness prevention. And this is a piece of legislation that Kim and I provided some feedback many months ago. And we knew it was still alive, but we didn't know that how much traction there would be. So it was unbeknownst to us that this was very fast moving. So the ask was, can we still do a January 1st distribution, but replace the requirements? And that grant, though it's for homelessness prevention, had really kind of specific requirements. It really was meant to encourage partnerships with community-based organizations and government entities, but it also had all the very, very specific, just very different than this. Though for ultimately the same purpose. So the state bar's response was, we've already put a lot of work on this RFP, but not only that, the work that we put and the commission has put on towards this, but we've already started to message this to programs, and programs have already started to plan around this RFP and they've reviewed the legislation, though they don't know, the ultimate outcome of the scoring rubric. So there's already been a lot of legwork done with the commission and the state bar, as well as legal aid programs. So there was a lot of back and forth. And at the end of the day, the legislation was amenable for us keeping for the existing legislation to stick. However, they did request, and we were amenable, and we said we would bring it to your consideration today to make tweaks to the rubric based on 1487 that were also consistent with this our current legislation. So nothing contrary, but places where we could enhance our rubric to reflect what was in 1487 we would do. So you're going to see some of that, and that's why there are some changes from the rubric that was posted last week to what we're proposing to you today. And then the other biggest change is because really the crux of that 1487 was about partnerships with other agencies outside of IOLTA community. They thought that, we brainstormed with the legislature, and a convening seemed to be a good vehicle in order to brainstorm ideas and share with programs kind of what partnerships could look like. The fastest date that we could come up with in terms of having a convening that we could put together that was meaningful was about 3 weeks out. The problem is with the approved timeline, if we go to do a convening on the 3rd week, and then we say, oh, here are all these great ideas, now only have a week to then put together a proposal, it felt insincere. So if we're going to put in all this work and make it really meaningful, we think that we need to stretch out the RFP timeline so that programs can have a fighting chance at putting together a meaningful partnership. So that's kind of the backdrop I wanted to provide before we show you the new proposed timeline. But with that, I want to invite Lauren, who's part of the Coalition for 1487, Selena and Bonnie to have any talks, because they have also had conversations with the legislature around this issue.
Kim
Sorry
Savage
for
also
the
has her hand up.
breaking news, but this all happened literally on Thursday and Friday, so it's very new to us as well.
This is Lauren Klein. Dawn gave a pretty complete description of what has happened over the last week or so, but I'll just add that the coalition that's been working on 1487 is comprised of a bunch of different nonprofits, many of whom are legal services organizations, and kind of the underlying goal of the legislation is to make sure that as many people can get representation as possible, particularly as we're facing this housing crisis, this eviction crisis. So partnerships are really important to the legislation because, you know, they allow for other entities like other community-based organizations to be doing things like education and outreach to free up legal aid attorneys to be doing the representation that is needed. So the legislation has been doing very well in the legislature. It's sailing through. The only thing that's left is a Senate floor vote, which should happen this week. And we expect the bill to pass. The bill is not funded. It does not come with funding attached. It needs to be funded separately, and it was not funded this year. So by partnering with the state bar, I think the legislature reached out because it really wants some of the goals of this bill to be met through the work that the bar is already doing, because as Dawn said, the goals are so similar. Ultimately, we're all working for the same thing. So LAC is certainly ready and excited to help with this convening and to help encourage organizations to engage in some of these partnerships.
It's thank you so much, Laura. Was there anyone else, Selena or Bonnie, that wanted to add in about the context? Okay. Well, I will show you what the timeline would look like if the convening were to happen in mid-September and we were to push back the due dates. So this is staff sort of proposed adjusted timeline, and I'll highlight the caveat at the very bottom, which is that this timeline would be subject to commission approval since the commission had voted for the October 1 due date and the subsequent review dates. So this would require full commission approval to adjust this timeline. But subject to that approval, the application would still release on September 1st, tomorrow. There would be a convening on September 21st. And then with about a month remaining in the application period, RFP applications would become due on October 22nd. So the whole application window is longer by about 3 weeks. And then it leaves about the same amount of time for staff and committee work. Everything is just shifted. So a January 1 grant period start date would be possible if the commission convened in early December before the holidays to finalize the award. So originally staff tried to make it so that the commission could consider the awards at its existing November 17th meeting. So this would require an ad hoc meeting of the commission. Any questions about this proposed adjusted timeline?
I guess I don't have a question about the timeline itself. I have more a question about the convening. And I guess I wouldn't mind hearing a little bit more. You know, we tried to do a convening the last year, and I'm curious what folks think about how that might be, you know, more productive. We had a lot of people in attendance last year with the goal of trying to direct people to sort of, I guess, partner in new and creative ways, as well as, you know, just come up with some novel ideas. I'm just wondering, you know, what Lauren or State Bar staff sort of expect and think might grow out of this, and whether we're going to get really a lot of folks attending who are, potential subgrantees, non-IELTS recipients, governmental actors, et cetera, that might be eligible for these funds, but didn't really receive them the first time around.
I can give an answer to that. I think that because of the participation of this coalition in this convening, I think that's going to go a long way to encourage some of these partnerships. There's a very successful partnership operating in LA already called Stay Housed LA, which is the model that 1487 was basically based on. So folks from Stay Housed LA can be there to talk about how this actually worked. And then we can also have a lot of entities there, organizations and government entities that are part of this coalition and may be interested in partnering. And we haven't set the agenda completely yet, but we talked about making time for breakout discussions so that legal aid organizations can talk directly to some of these community-based organizations about how they might partner. And we also anticipate that many legal aid organizations are already participating with community-based organizations that would be appropriate for these partnerships. And that would help with creating the partnerships also.
I don't have
Chris, there's a couple of people with their hands raised, and there's an attendee, Claire Salat, and William had their hand raised also.
Thank you so much, Kim. And Christian, since those might be public comments, I'll defer to you as to the right time to take them.
Well, I'd like to do it now. I don't think it will derail us too long. We'll just set it, ask everybody to keep their comments on point. But yeah, I think it's helpful to get it along the way.
Okay, I'll let Claire Slot talk.
Hi there. Thank you also for providing me with an opportunity to address the committee. I wanted to just piggyback a little bit on some of the comments that Lauren made. She and I are part of a group that's been meeting for several months now that was convened by Barhi, which the legal service community is actually the smallest group at the table. It's primarily tenants' rights organizations and other CBOs. And I think that what Lauren's suggesting in terms of providing a space for groups to collaborate and quite frankly, be introduced to each other would be extraordinarily helpful, given the fact that one of the things Lauren and I learned recently is that many of these organizations don't know who their local legal service provider is. So I would very much support that. I also think one of the important things to factor in is that there are several different groups that are working on grant funding for eviction defense. And I think that allowing these groups, as many opportunities to work together towards a variety of different grant initiatives, which collaboration seems to be at the heart of many, would be extremely helpful, as there's a lot of different demands on their time to get different grant applications in over the next 5 to 6 months. Thank you.
Thank you very much, Claire. And then Kim, was there any other member of the public that had their hand raised?
It's William. He should be able to talk.
Hello, this is William Boschelli. Hopefully I am allowed to speak and you can hear me okay. I'm driving, so it's a little more difficult, but I believe Claire may have answered my question on what value we gain from this convening, especially in the context of last year's convening, whether that had a lot of value that helped this mission move forward. And it sounds like the answer is yes, so thank you.
Which will.
Anyone else?
Bonachet and Kim Savage have their hand raised.
Okay.
I have just 2 comments. One is a procedural. So if we are looking at the full commission coming together to approve this new timeline, does that mean we have an additional ad hoc meeting prior to the November meeting and then another ad hoc meeting in December?
That's correct, Bonachet. And I did send out an email just because everything was fast moving and I didn't want to presume the direction that the committee would go to. So if you're agreeable, this committee, then what would happen is after this meeting, Bonachet, Eric, I reach out to you, the two of you first to see your availability for a meeting date, and it have to take place fairly soon after the 10 days. So somewhere around September 13th. And then I'd send a doodle poll to the entire commission to make sure we have a quorum for that mid-September meeting. And then we have to reconvene again in December. The staff has picked a December 10th date that will float by, again, Eric and Bonachet, you first before we float to the entire commission. And then that December 10th date we're hoping will work because it's a balance of us needing to be not so close to the holidays to get out grant agreements, but being also not too close to the date that the committee's meeting. So it seemed to land on the December 10th. So I'm hoping that date will stick. If not, then we'll have to visit some other days in December.
Got it. I just one clarification for the December 10th date. I think you want to now start speaking to Kim and Rich.
Oh, I'm sorry. Yes,
right?
Excuse me. Yes, sorry.
Okay.
Yes, right. Kim and Rich for the December 10th date, and Eric and Bonachet, you two are one more meeting for this.
Right, because the turn of
Yes.
events in November. So that's great on that. And then in terms of this convening, you know, I'm a big proponent of partnerships. I'm a huge proponent of collaboration, and I think that if there is that opportunity and we are able to meet that aim as a result of this convening, I'm a supporter of it, especially given the tsunami around the corner and bringing these organizations together. So if you know, I would really like to know more about the framework of this convening. I think that's where Christian's question might be going to, and I'm curious as well, to really make sure that we are setting the agenda. What are the measurable results? What are the milestones we're attempting to meet? One was just something I think Claire just mentioned, that there are a lot of organizations that aren't even familiar with the legal service providers in their communities. That might be one of the elements, but I'd like us to shape that a little more. And that's it. Thank you.
Kim, did you have a comment?
Yes, like Bonachet, I've always been a big proponent of the partnerships because I think that the community organizations are often very deeply rooted and we want the work to sustain after the grants. And having worked on the convening from the previous year, I'm quite concerned about the ability to pull off a really quality, worthwhile, substantive convening within essentially 3 weeks. And I'm not, so the convening last year, the focus was to encourage and cultivate new ideas, to get programs to think about things other than just traditional eviction defense work. So it seems that the discussion right now is focused on convenings to bring in partners, community-based organizations. I am not sure that a general convening is the best approach when really what needs to happen is that on the ground level, the programs need to reach out to the community organizations. So that's my concern. I mean, I can certainly work on it again as I did last year, but we felt jammed even with, I think, having 2 or 3 times as much lead time to put it together. We had a really tough time, and there was also no way to measure whether our convening really led to more creative proposals. So I would say that if the convening is not required, then we should think of other ways to cultivate the partnerships. And I think it's the programs that ultimately have to do it. So that's my perspective on it. But I just want to close by saying I really, really support the idea of partnerships with community-based organizations.
I just want to jump right back in really quick. And that's really the point, Kim, that I'm making. It's what are the elements? What are we really going to accomplish? So I think we're both speaking the same here.
Yeah, I will confess, I'm really struggling because obviously this is well-intentioned and there's already been some work to get it started, and it's definitely, you know, going to push out some deadlines. But I guess, you know, the purpose of the convening last year, as was mentioned, was to sort of prevent us from just marching down the same road of doing eviction defense. I don't know. I think a public convening is also, I guess I'm wondering whether a public convening is actually going to be more productive than just the behind the scenes work, unless there's enough time to actually make a presentation of some ways in which we think the money could be well spent, partnerships that could be formed, and that just feels like the timeline is extremely tight for any kind of substantive preparation like that. Yeah, I'm a little bit torn. I don't know if others want to comment. I mean, I appreciate the sentiment.
Oh, Dwan, I saw that you raised your hand. I don't know if you wanted to respond.
Yeah, I have a couple comments. So the convening that we did last year, it was a heavy lift. And I think a lot of that heavy lift was us trying to go out there and do research on kind of innovative projects to feature to our grantees. And, you know, it's hard to say whether then it had a positive impact. I mean, I think I personally saw some threads of those, what we featured in elements of our projects. Whether then that translated into increased services and quality services, I can't say. I think this convening, though it's also going to be a heavy lift, I think it will be less work in that I think the purpose is to hear, hopefully we can invite members of this coalition in the legislature to speak directly to our grantees instead of through the state bar in terms of what they envision the partnership to be like and what they envision a successful sub-grantee relationship. And then we're hoping to lean on LAC because LAC has done some work around, they were planning on putting together a separate convening that we're not gonna kind of smush together in terms of how to go out there and get effective sub-grants. So I think because it's a little bit more in the box and we have kind of the people that we're going to feature in the projects, it will be less work. But I do agree, Chris, Bonachet, Kim, a lot of this work will have to be done outside of the convening and partly starting, if it hasn't already begun, fairly soon before we wait until the date of the convening. I mean, I think I shared with Bonnie and Selena and Lauren this morning that like yesterday I had 2 calls with programs kind of brainstorming projects, and I brought up the whole partnership and they were very excited about it, and they were going to go back and reach out to a government entity to see if they can partner, another with some other their community-based programs to see whether they can beef up that funding. So I think a lot of it will be done outside of the scope of the convening. And this is where I think is a good role for LAC to go out there and really provide that technical assistance. And we need to start messaging that in advance of the convening in September. Next week, we're going to hold an informational webinar where we'll touch on some of these things to kind of encourage that. Yes, I agree with everyone, a very tight, compressed timeline, but we think, at least staff, though it's a lot of work, it's we're willing to put in the effort to get some type of benefit from it.
Lauren, go ahead, but I want to respond to Dwan, but go ahead, Lauren.
Sure. I was just going to piggyback a little bit off of what Dwan said. I think something that distinguishes this convening and this situation from the prior one is that we're not necessarily looking for programs to come up with brand new innovative ideas, though that would be great. Rather, here, there's a very specific set of problems that people are facing and ways that folks have partnered that worked. This is more, taking a coalition of folks that are already doing this, showing other programs how it'll work and saying, please do this too. Here are folks you can talk to. And I think the example that Claire mentioned is instructive. We were talking to some folks there. It was an entity that was aiding in the distribution of emergency rental assistance dollars, which are going to be really huge, obviously, in the coming year. And that entity said, we were having some trouble and we don't know who the legal aid provider is in our area. We didn't know how to refer. So making a connection like that will make a huge difference for the outcomes for the clients. That's just an example of something that could happen at this convening, encouraging people to identify who is providing the emergency rental assistance, what entity, and making sure that referrals are happening. That's something simple, something that's not going to take a lot of preparation for us to communicate in a convening like this, but I think something that could have a really big impact.
Will Bocelli has his hand raised.
Feel free to unmute Will again if we had remuted him.
Oh, sorry, I didn't realize I didn't lower my hand from before, but I will go ahead and ask a question. It seems like we're talking more about a networking event and sharing of information than necessarily convening. And the fundamental question that comes up listening to everybody's remarks is, does 3 additional weeks for the application deadline buy enough time for a real substantive difference in the types of applications we receive? And it's unclear to me based on the feedback so far. Thank you. I'll lower my hand this time.
And I'll take the opportunity to respond to that and to Dwan and Lauren's comments. I mean, my sense is that Will's characterization is right. This is at least, and maybe it's semantic, but a convening it as a networking opportunity is a little bit different. I actually object less to the extension of the time and more wonder whether the quote unquote heavy lift for staff is really as useful as, more targeted networking and connection making would be in a behind the scenes type of situation. Because I guess the critique of a convening to some extent is that it really isn't prescriptive, and I'm not sure it can be. So I guess I'm just wondering, how prescriptive we can actually be in a public hearing about, well, this is the kind of thing we want to see, and this is the kind of program and partnership that we think you should, pursue because you're going to get funded. I mean, I've never sort of experienced that kind of messaging, and I dare say that's not what would come out of this. So it just, I'm trying to be both encouraging, but protective of staff time, because I'm not sure that a public convening with a very public message, it just becomes more anodyne and not really prescriptive. Like, hey, pursue this, do this, make these partnerships because they're going to be favorably looked upon. Kim?
Yeah, I agree with what was just said. When I look at the timeline, I would hope that when that RFP is released, which is tomorrow, the wheels would already be spinning, and it wouldn't be until, another 2 weeks later, more than that, before there's a convening. And then a month later, the applications are due. And so to pick up on Will's networking terminology, I think that is what is being encouraged by Lauren and others, and I fully support that. And I'm just wondering if there's another way to encourage that without having this big forum. And I think, you know, LAC might have some ideas about how to do that and to make it happen more quickly. Maybe some sort of webinar. So, you know, the more I look at this calendar and think about what really is the purpose, as I mentioned before, which is pretty different from the previous years, I'm leaning towards something other than a convening to encourage the partnerships.
So I'm unsure who raised their hand in what order, but it might be Bonachet, Herman.
Yeah, so I want to echo some of what Kim just said. So when I first made the comment, I was asking for some agenda or something that we can hang our hat on, and it doesn't seem like that's been crystallized before this meeting here today. So I think I'm in the same camp as Christian and Kim. I don't know if it makes sense for this convening to be in this timeline out of the state bar. I think it actually should sit maybe with LAC or other groups that are pushing for the convening and supporting the partnerships. But I think that we may want to go back to the original timeline that the commission had already voted on, and support moving this forward rather than having the convening come into the state bar. I haven't yet heard what the meaningful actions will be to support the RFP and the grants and the rest of the work here. I think Herman is next.
My comment, are we asking them to do something that we want them to do rather than having this occur naturally? If I want to work with Christian and I see that Christian has this particular program, I would reach out to him. It sounds to me that we want to have them merge and do this great work, which I think is necessary. But are we forcing them, or should we just let it happen naturally if it's going to occur? And to push the timeline back, I just look at this, it puts more stress, in my opinion, on the staff to say agency A wants to merge with agency B. Now we have to spend this time to look at what agency A and agency B has done. If agency A and agency B want to work together, shouldn't that be natural rather than us trying to force them to do this?
Herman, and then Kim, is your hand up from before, or is that a new hand raise? Okay, Jim, you're next.
Yeah, if I'm understanding this extension and change of timeline, this is coming primarily at the request of the legislature to expand what we're looking at in terms of granting or making these or reviewing these grant proposals. And if that's the primary reason why we're expanding the timeline, I would suggest that we do it, because the more the legislature sees us working with them, I think the more the receptive are to giving us more money or continuing the money.
You're muted. There we go. Yeah, I agree with that concept, and I think picking up on something that Bonachet said, you know, I sort of think that maybe this, I like the idea of maybe having this be something not that we do, but that either LAC coordinates along with the legislature, or that others sort of focus on. I'm not opposed to the idea of extending the timeline. I agree. It does feel a little bit odd, to Herman's point, that we would be pushing for a certain outcome
and certain types of programs, although I don't know that that's exactly what we would be doing. I think we're encouraging partnerships, period. Seems like we're encouraging partnerships, period, and are giving a venue and an opportunity for programs to understand what each other do and what's available. But, you know, I'm, to the extent that it's sort of, we're throwing out sort of where we fall on this, I'm not opposed to the schedule, but I do think, you know, we might want to rethink how we approach what this event looks like.
Thanks. I mean, before Lauren, before you go, let me just say, in response to that and to Herman's comment, I actually think the State Bar's involvement as the grader of these applications will ensure that the presentation and the convening and the messaging is actually neutral in a way that's probably not helpful. So I guess the concern I have is that the State Bar's involvement in a convening actually waters down the message, because the conversation that the State Bar has to facilitate is, well, we're considering everything and this could be good and this could be good, and on the one hand and on the other hand. And it's not really going to foster, you know, a directive. It won't be prescriptive by definition, because we are the neutral grader of these applications. So yeah, go Lauren and Selena, and then let's try to wrap it up, because we've now done half an hour on this. So we'll let you two tie a bow on it.
Thanks, Chris. I just wanted to say that LAC had planned to do a convening of this sort anyway, and are very committed to making that happen. I know I'm hearing a lot of concerns about the State Bar's involvement and the staff time, and our staff at LAC are very adaptable and willing to make this work. So to whatever extent that is helpful, that's certainly something that we're ready and willing to do.
And to Christian's point about State Bar having to be very neutral in these, I just wanted to give a quick update that LAC had planned for tomorrow. We're doing a racial justice convening, and I think it's called Leveraging New Funding for Racial Justice. And we're highlighting the homelessness prevention dollars, the increase in Equal Access Fund and the increase in IOLTA as examples of funding that could be used for racial justice by legal aid programs. And so we are able to be the advocates to say, use these dollars for these reasons. And so we're already open up the conversation with our community. And it would be quite easy for us not to, I don't think we should replace the convening around partnerships with this racial justice one, but I think I can lift up in the racial justice convening the importance of working with community-based nonprofits, especially BIPOC-led community-based nonprofits. So that's already kind of like teed up, and we are in the convening business. You know, as Lauren says, we do this all the time. We can host a Zoom next week and have it all ready to go. But we are able to be less neutral because we really want to push our community to do more. So that's at least something that's a benefit of LAC doing some of this work.
And just to quickly address what Chris was saying about what the legislature wants, or maybe Jim was saying, or in Kim's question in the chat, I think that the legislature wants to see these partnerships happening. The legislature did not request a convening. I think that what they're looking for is not just that the grants permit subgrants, but that in some way it is, you know, made more visible to programs that this is something that's good and encouraged and something that they want. So to whatever extent we can make that happen, I think that that would make the legislature happy. I don't think it necessarily has to be with a convening. That's just something we came up with that we thought could really encourage these partnerships.
Well, I guess, okay, so I'm going to sort of see if there's some consensus here. I think, at least as I read the room, we actually are in agreement that the State Bar should stay out of a convening. We are broadly in support of partnerships, broadly in support of networking, broadly in support of the State Bar providing necessary support, answering questions, making connections, and facilitating things on behalf of programs, and in maintaining those kinds of communications with LAC and with the community. But there's also sort of I think a resistance to having the state bar host and or facilitate the convening. So the secondary part of this is whether we believe that the convening is useful enough to the community to warrant and justify a delay in the timeline that would necessitate another commission meeting to approve. I think most people have indicated that it would be useful to push forward and to make this networking occur. If I'm misreading the room there, I would like to sort of hear from somebody who disagrees with that, because otherwise I'm going to sort of push the conversation forward by saying bar out of the convening, bar staff out of the convening, except in however much of a support role LAC needs, and push forward with this adjustment to the timeline, because it's going to facilitate better partnerships, which is really what the legislature's goal is. I'm going to encourage a hand raise if you disagree with that assessment. And if you don't disagree, put your hand down. And I can't see everybody's hands. And then we're going to turn back to the presentation of the rubric with Chris if there's no hand raised.
Will Bocelli has his hand raised.
Okay.
Will, are you going to talk? You can talk. Okay.
Oh, okay. I wasn't sure. I was just thinking of what Herman said about groups actually coming together, and it doesn't seem to me that 3 weeks is a lot of time if there is a strong interest in coming together to change that. So I'm not sure how much the 3 weeks to get an application in allows for additional partnerships that would not happen otherwise. That would be my concern. Thank you.
All right, let's head back to the slide deck, Chris.
Chris, before you do, there are a couple questions in the chat, and I think that Eric is asking something. He said it's a repeat. You may want to respond to that before we move forward.
I think though this is covered by the slide deck.
Okay, very good.
Okay. But thank you for drawing my attention to the chat. So when there's a moment where someone's talking, I'm going to read through the chat and make sure we captured all the questions. Okay. So the next few slides mostly describe the rubric as presented in the posted materials. There's maybe like 2 or 3 areas where we've showed, we like in different color font, we've showed like how the RFP or the rubric could look different if the committee wanted to emphasize partnerships. But I'll point that out so you can see that that was different. The proposed, I would frame this by saying the proposed rubric has a similar structure to the rubrics for a couple of the other competitive grants that the commission administers, namely the partnership grants and the PLL grants. This staff had proposed this to increase predictability for applicants, but also over time consistency in how the rubric is interpreted, and then the corresponding efficiency that comes with that. And when I show you the rubric on the next slide, I'll detail like what the structural similarities are, but essentially it's like the meets, exceeds, and below expectations columns. So to highlight a few of the changes from the what we call the Hb2 Competitive Rubric, which were the 2021 through 2023 competitive grants. The Hb2 rubric it actually had a criterion for serves clients regardless of an immigration or citizenship status, because the authorizing statute actually explicitly stated that that was worth preferential treatment or special points. Since that was not included in this year's statute, staff proposed to not make that its own criterion worth its own points this year, but instead to just say that this is an example of an underserved community. Another change that staff proposes is to separate serves rural or underserved communities. This was a combined criterion for the Hb2 rubric, and staff observed that during scoring, there was some uncertainty around how to, the way the rubric was worded sort of seemed to necessitate that someone could get full points for serving either rural or underserved. And it felt like a program that would do both maybe ought to get more points than one that was just going to do one or the other. So since the legislation this year also says preference is to be given to proposals that would serve rural or underserved communities, staff proposes for your consideration separating those into separate criteria. So the rubric does that in different rows. It removes potential sustainability, continuation of proposed services in response to feedback from committee members last winter about how that criterion was challenging to apply and seemed to also incentivize really long-term projects and disadvantaged projects that could be completed in 3 years. And then it also proposes to replace references to innovation with points for focusing on litigation strategies. And then I'll just take this moment to note that we received some advanced feedback from at least one committee member that perhaps better than litigation strategies would be a reference to full scope representation. Staff's reasoning, staff would support that substitute if the committee was leaning that way. And the reason for recommending this change is that because these are federal dollars as opposed to the Hb2 dollars, which were from the state's general fund, I think, there is an emphasis this year to report outputs and outcomes eventually to the federal government for, quote, evidence-based activities or evidence-based interventions. So there is sort of a preference from the federal government to select proven strategies to ameliorating homelessness. And so we thought a focus on innovation might run counter to that, whereas a focus on full scope litigation or litigation strategies or full scope representation would support an evidence-based interventions.
What does that mean? I don't know what that means, full scope representation.
So I would describe that very generally as taking on a client's case to address help them resolve the legal matter from beginning to end, as opposed to providing only counsel and advice, or agreeing to send like only a demand letter to the landlord, but then you cut off the services. You don't agree to take it all the way through litigation or to the full resolution of the legal matter, but seeing it all the way through. So I'm going to advance the slide just so you can see the rubric, but I anticipate spending quite a bit of time on this slide and encourage the committee members to really grapple with some of these like changes, since these are different. Oh, pardon. I thought the next slide was the rubric, but maybe I'll just touch on this very quickly. The rubric, staff would note in the RFP that it's a tool to guide the committee's evaluation, that scores do not guarantee funding. This is also true of the partnership grants and PLO grants rubric, but the score does not itself guarantee funding, and that the commission or committee can exercise discretion to make awards that accomplish the goals of the authorizing legislation. For instance, the staff would encourage the committee, after all the scores come in, still to take a look to see that grants are being distributed across the whole state. It's not entirely concentrated in San Francisco or LA, for instance, and also perhaps to strive for diversity of homelessness prevention interventions, since AB 164 lists so many different ways that someone might try to ameliorate homelessness. So both of these sort of post-rubric analyses would happen after scores are done. And that might be an example of how the committee might break a tie, or why what particular score might not guarantee funding. Okay, I'll advance the slide, but I anticipate spending quite a bit of time on this one, and we'll turn it over now for questions. I see Herman has his hands up. So Herman, do you want to start us off?
Yeah, I want to go back to the other slide. When you said a high score does not guarantee funding.
Yes.
So does that mean if a program in LA happens to get a really high score, but a program in Humboldt County didn't, that the monies may go to Humboldt County rather than this program in LA that got a really good score?
That's correct. Yeah. So just to use an extreme example, staff envisioned like if 90% of the highest scoring proposals were all going to serve LA County, and there was a proposal that would serve Humboldt County and it scored a couple points lower, for instance, the committee might want to exercise discretion to make sure the far northern proposal was funded.
And then what do you say to the program in LA?
So the one tact that the staff could take or the committee could take is that it exercised its discretion to best accomplish the goals of homelessness, being that AB 164 seeks to address homelessness statewide and not just in one geography or in one particular way, that to accomplish the statewide goals of the statute, the committee exercises discretion in that way.
Selena?
I think just to echo what Chris is saying, I think transparency is just important, that programs understand that there will be other factors at play, including the desire for statewide funding, and that if the majority of the applications all come from one county, the other counties may be treated more favorably for that reason. And I think they're all sophisticated. They also understand equity issues in our state and how rural resources do not match the resources that are available in urban parts of California. And the urban-rural divide is definitely one, and I see Jim, urban-rural divide is one that even urban legal aid executive directors fully understand that it's a crisis. So I think specifically with this hypothetical example, were it to be something that became true, I think organizations would understand.
Just Lena, Jim.
Yeah, Chris, I was just wondering, since we're trying to accommodate the legislature by stressing partnerships, how would that be accommodated in the scoring rubric?
I'm so glad you asked, because yeah, now you might be wondering why there's the blue word partnerships here. So this is a proposal for the committee's consideration that was not part of the posted materials. So the one change here is in blue in the organizational capacity row. Having heard in the last week that the legislature would really like sub-grant relationships and partnerships to happen, that is something that they hope that becomes encouraged. The scoring rubric could specify that partnerships is relevant to organizational capacity. The rubric as posted just says, applicant demonstrates that it has the qualification, experience, and resources that it needs to meet the proposal objectives. So it could just be more explicit that partnerships is relevant to organizational capacity. And then in the RFP, there's a description of, there's guidance for programs as to what organizational capacity means. So it kind of elaborates on other relevant factors, and that too would be updated to reflect that partnerships with IOLTA and non-IOLTA programs is relevant to organizational capacity. All right, Eric.
Just a couple things. On splitting up the rural criterion from the underserved criterion, if a project serves a rural area, but that rural area is also underserved, which I assume probably will be necessarily almost, does that project get points in both criterion or only one?
That's a great question. I will speak for myself, and Duan can jump in if she disagrees. My interpretation of staff's proposed rubric is that if the underserved element is the fact that it is a rural community, that would be points for focus on rural populations, and that focus on underserved populations, the criterion just below it, envisioned non-rural sort of like ways that someone might be underserved. It could be mental health issues, or perhaps some other reason why they experience higher than normal barriers to accessing civil justice. but then if that is the way the committee lands on it, we would need to spell that out, I think, in the RFP.
All right, so you don't get double credit for being rural, essentially.
That's correct. Now, that was my interpretation of staff's proposed rubric, but Dwan, is that, were you thinking of it differently?
Yep, that's exactly how we read it, yeah.
So I had two other points. One is that the special consideration criterion, to me, feels somewhat duplicative of the project impact criterion. In other words, if the project is really great and has a wonderful, strong impact, I suspect it's going to come out strong on that special consideration as well. So I don't know. I just think there's a potential for double counting there. I mean, I'm not sure I understand this special consideration thing. I made this comment to you, Chris, in an email. So I have that concern. And the other comment is on the partnerships thing. If you have an organization that is just strong, one of our stronger organizations like Public Council or Beit Tzedek or whatever, some of the other ones that just have a strong organization, are they going to suffer if they don't enter into a partnership?
They would not. I would propose that they not suffer for not entering into a partnership. That it be a factor that could strengthen somebody's proposal, but that the absence of it would not disadvantage them. Would be my proposal.
I mean, should we? I'll just raise the question. I don't really know what I think the answer is, but since we seem to be so focused, and the legislature seems to be so focused on partnerships, I mean, should we actually just make that a separate criterion that gets people credit?
Well,
raise the question.
So I think I can answer that really quickly. So we did contemplate that, but it's not specifically in the legislation. So we didn't carve out a specific category for it, is what we thought would be the safest.
If the other committee members were wondering if maybe there were a different factor that would be worth special consideration points than litigation strategies or full scope representation, I suppose it's worth noting that partnerships could be the special consideration category.
Christopher, this is Kim. That's where I was going. I was thinking that partnerships should be under special consideration. And I'm not sure that litigation should be called out there, given the length of the grants and how long it takes to cultivate litigation and move forward on it. I'm not sure that litigation is necessarily the singular thing we should mention there. I do think that it's a really good spot for partnerships, given Dwan's most recent comment about, the legislature not requiring it, but the messaging coming to the state bar that they really like partnerships.
Just really quick,
I would throw that out.
Just really quick, piggybacking really quick on what Kim is saying. So organizational capacity right now, we have and partnerships that's been typed in blue. So we're highlighting partnerships, and it sounds like it's not connected by an or, it's connected by an and. So yeah. Partnerships has to be a part of organizational capacity is my read of it.
I agree. That was another problem I had. It looks like it's an essential element that will be evaluated.
Go ahead, Bonnie, and then Herman, and then Jim, or Jim and then Herman.
Thanks. So, I mean, another possibility would be to have both partnerships and the evidence-based practice. So the federal government has, as noted, has a lot of restrictions on these funds. And one of the things they ask for is they have an interest in promoting projects that have evidence-based support. And the only thing we have in this field, don't do a lot of random assignment and control studies and things like that, is actual representation in eviction cases. That's I think we may want to, that's why I was suggesting that that might be an appropriate criteria. That would be obviously a very different timeline than the kind of work that Kim is describing. And maybe it's the kind of thing we might be more explicit about, and we could, but you could have, you know, special criteria, presumably for partnerships or representation eviction hearings. And I know it's boring, but it is the one thing that we can show through the kind of test that the federal government is interested in makes a difference.
Jim and Herman.
Yeah, I just wanted to echo what Bonnie was saying, perhaps because she and I have discussed this in a little bit more detail elsewhere, but the Office of Management and Budget is really stressing that when they're handing out this money that is based on evidence-based research, meaning that there's research out there that shows that this particular intervention is effective. And perhaps you don't need litigation in there, but we do have another number of studies, especially under our own Schreiber projects that show in this area when there's representation, the clients do better. And since, you know, we want to appease the feds just like we want to appease the legislature, I think it's important that we have this in our scoring rubric. And in addition, I would say it ought to be 10 points. I would take 5 points away from project impact and reallocate it to 10 points down below, because in order to get the special consideration, you get full 5 points. Well, that's less than what you would get for not below expectations in the other two categories. So I would raise it. And to handle Eric's question on the partnerships, I would read that or partnerships. And I would say that you could have everything but no partnerships. I would say that would meet expectations. That would be 15 points. But if it has the organizational capacity and it also has partnership, which is what the legislature wants, I would say that's what you would need to have exceeds expectations for the full 20 points.
Herman?
Yeah, but I'm going to address something Jim just said, that, and I think someone raised it, I may be a great agency and I don't need a partnership. I shouldn't be penalized for that. What does number of check marks mean?
So that's something that we just borrowed from the partnership grants rubric, where you would, you know, it only really becomes relevant in the 3 rows that are separated into 15, 10, and 5 points, where you might have like a check mark for in exceeds for the focus on rural, a check mark in meets for focus on underserved, and a check mark in below for project evaluation. And then you would multiply the number of check marks to get the number of points for that subtotal.
All right. And then I want to go to focus on rural population, focus on underserved. If I understood correctly, someone said focus on rural populations. Then if someone is in a rural community and they are mentally ill or have substance abuse issues, that's also underserved. So someone in Los Angeles, which is urban, will not get points because it's not a rural population. But someone in Humboldt, who is a rural population, but also working with people who are mentally ill, people who are substance abusers, people who are homeless, they're getting an extra set of points compared to an agency in Los Angeles that's not rural. Am I understanding that correctly?
You are understanding correctly. And that actually, hearing you ask that question out loud makes me, it's maybe where you're going with it, makes me wonder if by separating it, it's possible that someone could articulate a very compelling project focused on rural communities, but otherwise isn't particularly serving otherwise underserved clients, and they might get a not addressed or below expectations. And I wonder if that's the outcome we want. That would be a result of having separated them into different rows.
I don't know. And then, hold on, let me finish. And then the project evaluation, the applicant details. What do you mean by details and evaluation strategy? Because how I interpret that and how Jim may interpret that may be completely different. because of the work that we've done in the past?
Staff just means by that describes in detail.
Sorry?
Oh, staff, by using the verb details, staff means the applicant describes in detail.
What do you say?
Well, if you wanted, we could change it. The two rows above use the verb articulates. We could change it to articulates, and staff's proposal would be the same, substantively the same. We use the synonym to just use a different verb. So we could change the word details to articulates if that helps.
It's not the word. I'm just trying to figure out what is it that you're looking for. What would we be looking for if we're looking at an application?
I see. Yeah, I thought you were asking about the word choice. So the RFP provides a little bit of guidance for each of these rows, and I actually have it up. Let me just read, because it's only like maybe 2 sentences. Let me just read that one. So project evaluation, the guidance, and this is from, this is a little bit informed by the partnership grants approach. It says, applicants should describe an evaluation strategy, frequency, diversity of approaches to collecting information, et cetera, and resources that are likely to yield data in time for course corrections and refinements during the grant period.
Will we get that information when we look at this rubric? Will I have access to what you just read? So then I know exactly what you're asking in regards to project evaluation.
Yeah, so the explanations for each of these rows was provided immediately under the scoring rubric in the posted materials for today's meeting. And in the RFP that programs see, it would be the first thing that comes under the scoring rubric would be the explanations for each of the rows.
Okay. Thank you.
Jim, hold on. I want to make sure that I actually didn't misunderstand the first part of Herman's question in the comparison between LA and Humboldt. Did Chris understand your question correctly, Herman?
I don't exactly know. I just know that if I'm reading a Humboldt application, I know that Humboldt is in a rural community. Humboldt may be serving as someone who's mentally ill, homeless, a substance abuser. I would want to give them points there. But if I'm looking at an application in LA, they won't get points for rural. So it means that Humboldt would get, say, 20 points for the focus on rural population, where LA would not get any of those points, but then Humboldt may also get 20 points for underserved population. And so though Humboldt would end up with 40 points in that category, where LA would only stand to get 20 points in that category.
I see. So I don't think, Chris, my sense was that you did not, that you answered a different question than what Herman asked. I think what Herman is basically saying is that all things being equal between two applications in terms of serving multiple communities, et cetera, rural is a 20-point differential. And you answered that is yes, correct?
The answer to that would be yes for a program that would score and exceeds on rural versus a program that didn't address it.
Okay.
Because they don't serve rural. It would be a 20-point
difference. Isn't it 15, not 20?
I suppose if
no,
they
it's
don't,
20. It's 20. Sorry, it is.
Yeah,
20.
I suppose if a program like was not going to serve any rural client, if they were to score and not addressed for that, it would be a 20-point difference between a program that exceeded in that category.
But if a program is in an urban area, it's going to lose just because of its location. Well, if you only want the funds to go to rural, then say, let's give the funds to rural, but don't punish an urban organization because they don't serve rural population.
Well, the one thing I would say, I think it's a really good point. The one thing I would say is the statute says preference shall be given to programs that serve rural and underserved communities. So how the committee wants to embody that in the scoring rubric is I guess the question for today. And so it does require preference to rural or underserved, but maybe this isn't quite the right structural way to do it.
Well, I think the question is about weight. And the one thing I'd say, Herman, I'll play the devil's advocate, which is just to say that the number of program applications involving rural communities or focusing on rural populations is much smaller. I think you might be onto something that 20 points is quite significant, given the total number of points.
I thought it was 15.
Am I missing something?
It is 15. You need
that's what I thought.
Yeah, you need to vote. Yeah.
It's 15, and I have an elaboration on Herman's question. If you, just because you're an LA program, if you're an LA program that's just addressing homeless vets downtown LA, you wouldn't get any rural scores. But if you're an organization in LA that's doing outreach to Antelope Valley, which is more of a rural area, at least according to MSSAs, then you would get, I would say, not 15 points, you get 10 points. But if you have an extraordinary outreach effort to go out and actually recruit and contact all the homeless as opposed to just merely serving that community, then you would get the exceeds expectations for the full 15 points. And yeah, I think that's an important difference. Somebody that's doing that, and it doesn't exclude LA from doing rural stuff. The only places that's going to exclude for doing rural stuff would be Orange County, which has no rural MSSAs, and San Francisco County, which has no rural MSSAs.
Well, if I may just step in, I'm going to make an assumption that there is such a large homeless population in LA proper that agencies are trying to provide services to that particular population. They may not have the time or the staff to go out to Antelope Valley because of what's here in LA. I don't know when the last time you were in LA, Jim, but the homeless issue is just so magnified at this point that that I don't know. I just from what I'm reading here and is that if a program is in an urban environment and it does not reach out to a rural community because of where it's located, it is going to be penalized. And then previously we said, if there is if a rural program and an urban program have a close score, just to spread the monies out, we're going to select the rural community rather than the urban, which may be appointed to. I just don't want urban programs to be penalized because of where they're located.
Well, if I could step in for a minute, I mean, Herman, I think you're overstating the penalty that might be experienced by the exceptional urban program. If you've got an urban program that has a really unique project impact and an excellent organizational capacity and does really well in the special consideration metric, that program is going to soar. Even if it doesn't get the points for rural, it's still going to score high, and they score higher than the Humboldt County program. So you have to kind of look at all of these criterion together, but we do give some preference to rural programs because that's what the legislature's asked us to do.
I appreciate your comment, but that's anywhere from, that's 15 points that Agency X in LA won't have access to, where the program in Humboldt will have access to, if they get a check mark and focus on rural, a check mark in underserved, and a check mark in evaluation, that's 3 times 15 is 45, whereas a program in LA may only get a check mark in underserved and a check mark in evaluation. They lose out on 15 points.
Well, I guess, make no mistake, I mean, Herman, you're expressing an advocacy position for urban programs, and it runs counter to the directive of the legislature. So, I mean, I guess, you know, just going based on our last experience in running these competitive grants, I guess I didn't see the impact on LA-based or urban-based programs play out. But I hear what you're saying. I'm just not sure, other than advocating that we allocate a smaller number of points, how you would propose addressing it. In terms of the other comments and just sort of noting, I think we can change under organizational capacity. There seems to be consensus to change or partnerships rather than and partnerships in the blue there. And my recommendation on the special consideration would be just to change the word litigation to advocacy strategies, which could include litigation, but would be a broader potential category rather than, you know, litigation specifically. And that might address the concerns that others have raised.
Do you see that as distinct, Chris, from project impact? I'm still having trouble distinguishing experience.
So, sorry, I'm sorry. Was that Chris McConkey or Christian?
Either of you, either Christian.
I'll let Christian go first. This is the chair if you have thought about that.
Well, I guess I see project impact and strategies as being a little bit distinct because, well, the thing that to me that on the Venn diagram is the strategies piece in the top category, project impact and strategies. To me, the way I made sense of it is that the project impact and strategies, seeing that as a unit, meaning the strategy is intended to affect the impact that the program is trying to bring on. So in other words, if somebody's trying to have a land use impact and they're doing eviction defense, the strategy is not tied to the impact. So I saw that as a single unit. The special considerations advocacy strategy down below, to me, is a discretionary category that would allow the committee to score applications with an eye toward, I guess, privileging novel approaches or you know, other ideas that might be creative or new. That was how I made sense of it.
So you're reading it as innovation.
Well, I think an advocacy strategy, though, could be, it doesn't necessarily have to be new, but I do think, like, as a special consideration, like, for example, let's say you had a program that was employing formerly homeless individuals to do outreach work, right? Like, to me, that would be a special consideration. That's a strategy. It's an advocacy strategy. I would say that as a general matter, that's it is innovative as far as I know, but it's also, you know, it's a strategy to be a more effective advocate, I guess.
Chris, if I could add on to that, I view those as completely different in that the special consideration is based on the Office of Management and Budget's preferred use of strategies that have been proven through research to have an effect. And we have in the housing areas a number of studies in New York, and we also have the Shriver studies, where if you randomly assign housing cases, some get representation with an attorney and some don't, that the ones with an attorney do better on a whole slew of different measures. And that is based on research outside of this project. That's what the OMB is interested in, not necessarily innovation, but they're interested in interventions that have been based on outside critical research.
Well, we could certainly make that clear in the in that category. I don't think anyone would really object to at least adding something along those lines.
Mm-hmm.
If that's
I would still advocate it ought to be 10 points and take off 5 points off of the work capacity.
I'm making note of all these potential updates for the final slide. We have a resolution, so I can stick a bullet in there that says like, take 5 points from one and give it to another.
So let's go Rich, Dwan, Bonnie, Kim.
Yeah, I'm curious about the notion that the focus on rural populations and focus on underserved populations imply an equivalency. The way the scoring reads, it's explicit. These are equivalents. And I took from Herman's comments the notion that maybe the populations being served are far from equivalent, that the urban homeless populations are so far greater than the rural homeless populations that these aren't equivalents, yet the rubric treats them that way. And the legislation isn't helpful because the word or doesn't tell you that these are equals, but yet it shows up here in the rubric as being so, and that's a fair interpretation of the legislation. So I think there's a mismatch in terms of the legislative intent and the way this rubric reads as to whether or not these are to be given equal weight.
I just don't want to lose that Dwan and Bonnie have had their hands up for a while. And they may have had a comment about an earlier point. I just want to make sure that doesn't get lost.
So yeah, I was just responding to Herman's point from earlier now, Rich, too, that I just want to remind everyone that though this competitive is only 25%, the other 75% is based on formula. And so that takes into poverty into consideration because it's based on the IOLTA formula. So there is a substantial amount of money that's being funneled to counties like LA that have a high poverty rate. My second point is with urban programs or non-urban programs, the program is making a choice on where to serve. Just because you have an office or you're currently serving clients now in a particular county doesn't mean that you're prohibited from there. In fact, we have seen some of our more successful programs that are kind of sometimes the larger programs and more sophisticated programs have gone out to more rural pockets of the state and then collaborated with other both IOLTA programs and non-IOLTA programs and brought out those services. And that's been done really effectively. And I would, if that was the case here, and if they were based in LA, but they were going out to San Bernardino, I would hope they would get an exceeds or at least a meets in that rural category.
And I guess I would also say that the reason this has been a policy discussion and for a number of years, and partly because there's such a huge disparity between legal services funding in urban areas and rural areas. And it's literally like hundreds of dollars in San Francisco and LA to $10 in a lot of rural communities. And the legislation in 1487 specifically called out a number of rural counties, but I'll track down the numbers specifically. I'm sorry, we have it in our report on the self-help centers, but it's just a stunning difference. And also urban communities tend to be able to get more pro bono assistance. They tend to have other funding operations, that kind of thing. So I suspect that is why that was called out by the legislature. And there are people who know this field much better than I know much more about the actual data about homelessness in rural communities, but it's certainly a big issue there as well.
And then I see Kim and then Eric.
Okay, I just want to kind of piggyback on what Dwan said in relationship to Herman's concerns, which I totally get. And what I wanted to say, which may somewhat appease you, Herman, but maybe not, is that there are a number of very large legal services programs that really cover a big swath, both urban and rural. Legal Services of Northern California, has office in Sacramento, but it hits a lot of really small rural communities. And the same with California Rural Legal Assistance. It has offices, regional offices in the city. And then it really covers a big swath of rural California in the Valley. So, so there are programs that really are hitting both. And then like Dwan said, there are urban programs that basically shaped their proposals last year to reach out to rural areas. My concern really is the difference between rural and underserved. I mean, the legislature has really called out the fact that rural is underserved. I've always had a heck of a time coming up with any other population that is underserved, because overall the entire universe of poor people that these programs serve, they're all underserved. So I had a hard time even finding anything other than rural that met a definition of underserved. And then my last comment is in regard to that language that was added for consideration and organizational capacity. I really would move partnerships out of there and put it down as another possible special consideration. I mean, even if I change it to Chris's suggestion of or partnerships, it really messes things up in the reading of it for me. I don't think we have any kind of ors in here. I mean, a capacity means, the qualifications, experience, and the resources. So I don't know how to rework that. So anyway, I know you've got more slides to go through, and we're holding everything up here.
I would just to forecast ahead, the next couple slides is like what the application looks like and the reporting, but I actually think this resolution is just about the scoring rubric. So this is more important in my opinion.
Well, I guess, Kim, just briefly before Eric and Jim, but I guess I was reading and partnerships maybe a little differently, and I agree with what you're saying. But I guess I was seeing the organizational capacity of both the applicant and the partner, as opposed to giving them credit for having a partnership. I agree, we should move that out of there as a function of capacity, but I was reading the partner of the applicant or partners or whatever as being possibly able to contribute to the capacity of the organization that's applying for the money. That's how I read it. Sorry.
Oh, okay, I get it now. Okay.
Chris, Eric and Jim, do you want to talk before we go back to Chris, or your hands are still up?
Yeah, I just wanted to, I'll just focus on the rural underserved. I wonder if separating these two is, at least in my mind, creating more confusion than clarity. I wonder if we shouldn't just move back to making it one criterion. For example, if you're an LA project that makes some attempt to serve rural areas, maybe you'll get some points on the focus on rural populations. Maybe you'll get a below expectations if you do sort of a not great job, or maybe you'll get a meets. But then you'll also get points for serving underserved populations. That just seems, I don't know, it just seems like, Herman, maybe you're actually going to privilege urban projects if you do it that way. I don't know, it just seems potentially confusing to me to have them as separate criterion. That's my point.
Yeah, so right, so yeah, in the Hb2 it was, which sort of predates my time with the Office of Access and Inclusion, but I went back and read the minutes from the scoring meetings, and yeah, they were combined, so it was a maximum of 10 points, I think, that someone could get for serving rural or underserved. So if we went that route, I think staff would just want to be more clear with upfront about whether or not someone could get maximum number of points for just doing one, or if a program should be able to get more points for doing both. Jim and Dwan?
Yeah, just a further elaboration on the rural-urban split. I don't want to keep casting aspersions on Yolo County, but we have been using that as an example. But I think another way, a place where the scoring will differentiate between urban and rural is on the first one, the project impact. So if you had a rural proposal that's going to address the homeless issue of all 100 vets that are homeless in Yolo County, as opposed to a program that's going to address the thousands of veterans that are homeless in LA County downtown, then clearly they're going to have big differences in their scoring in terms of project impact. A project that's impacting thousands is going to score much, much higher, at least in my mind, than a project that's going to impact 100 or two.
And then Dwan, you had your hand up next.
I was going to say, yeah, Chris and I did go back and review the recording and the summary from the last HP meeting where we talked about where we actually put the rubric into effect. And when we combined the rural and underserved, there was a lot of confusion in scoring. Like we didn't know how to calibrate. If you know, that's why we moved towards separating it for clarity. It seemed like across the board, everybody had disliked the fact that we had combined it before when we had went to use it. So I just want to remind everyone, that's why we went to split it.
I agree. Personally, I think it's better to split it out. I think Herman's concern is about weight. I mean, we can't run from the statute. So I think the question is it, if it's a standalone category, is it worth 15 points? Or should it be less? I mean, to me, it's almost a binary. Because it either does or it doesn't. I mean, I don't know. I know we have 3 categories there: exceeds, meets, and below, and Jim's articulated a way that it might exceed. But the vast majority of urban applications are just going to be zeros.
Or rural, but what about for underserved?
Well, that's what I think Juan's essential point there is: keep them separate. Then rural is really, it's in its own category. It's either going to be a 0 for the majority of urban programs, or it's going to be, you know, maybe many meet, some exceed, but it's you know, we're not going to see. It's easier to keep it separate because then it's just, you know, you get the bump, you get the privilege per the legislature. But I think to Herman's point, 15 is a lot because that's a big difference here in the total amount. So I guess my recommendation, just to try to thread the needle here, would be to turn that into a 10-point category and make the anything. I'd actually put it into a two-prong category. Either you address it or you don't. Either you have some rural community focus or you do not. And yeah, go ahead, Chris.
Oh, that's very easy to do, like in the rubric, to make a rubric look like that and make sure the points still add up. Is there when staff was sort of thinking about that internally, we'd sort of talked about how maybe an applicant would propose to serve you know, one rural, like the rural parts of a rural suburban urban mixed county, and another one would serve 3 counties, another one would serve like 10 rural counties. And maybe like some gradation of rural would start to emerge from the pool of proposals. It's kind of a theoretical way of thinking about it, but we're like, okay, maybe there's a way you could give more points for different versions. But
yeah, but I guess, I mean, my response to that is that if you're serving a rural, if you have a quote unquote focus on a rural population, then you get bonus points. Whether you're focusing exclusively or in part or in a large geographic area or a small, you get your bonus points. The project impact and strategies is going to pick up the difference there that you're describing in the gradation of how much you're focusing. So, or how big an impact. I mean, again, I'm not married to 10 points or 7 points or 5 points. I do think we have an obligation to identify those applications that focus on rural communities, and we've got to effectively bonus them in some way. You know, I guess I'm falling in line with Herman here that 15 points is a lot. Given the spread that we saw in the first round of competitive grant funding, 15 points would have like really jumped somebody way, way up. And that may or may not be warranted. Jim?
Yeah, my recollection when we went through this last year, we had the distinction between rural and underserved, is that there were some grant proposals just said, we're going to address rural needs. No issue of outreach, no issue of specifying where in the rural that they were outreaching to. So, I mean, for me, that would just barely meet expectations as opposed to exceed expectations. The point being, I don't think it's just binary. I think, yeah, there's going to be a lot that doesn't address it at all. And that's a 0, but there's going to be some that says, yeah, we're going to focus on rural and not elaborate, not showing how they're going to do outreach or extension or focus on the rural or organize in the rural. And I think you need to have more than just a binary 0, 1. I think there at least ought to be a 1, 2, 3 or a 0, 1, 2, something. But those who really elaborate how they're addressing specifically rural needs and how they're going to outreach to them is something more than just merely saying, yeah, we're going to serve rural clients.
Claire Salat and Will Bocelli has their hands raised.
Go ahead, and then we're at 4 o'clock here, so we've got to get back to making some decisions and getting done. So go ahead, Claire, briefly, and then Will, Sam.
Hi there. I was just going to elaborate on the comment I put in the chat that you all are not the first to be facing the urban-rural challenge, and what the Cal Endowment did, which I think some of you know that I'm involved in a group that's working on the CLA side of this, is they just separated their money into 2 pots, one that goes to rurals, one that goes to urbans, and that way you take this rural question out of the purview of the rural groups that are applying. It's much more of an apples to apples, which I think as someone who spends my day reviewing grants, it's much easier to be able to be effective when you're doing it within that kind of closed universe. The other piece relating to that is you could skew the money allocation if you feel that the instructions were really to lean towards rurals. Instead of it being a 50-50 allocation, it may skew 60-40 or something different like that. But it would eliminate all of the challenges you all are facing by trying to look at urbans and rurals under the same lens.
Will?
Oh, there you go. Can you hear me?
Yes.
Thank you. I just wanted to encourage whatever the decision the committee reaches that we keep in mind the transparency purpose of the rubric as I understand it, and that's to communicate clearly with the applicants what they're getting points for and what matters in terms of funding. So whatever choice is decided upon, I certainly, the more divided up and the more clear it is, the more sense it makes to me. And then on the project impact, on the Partnership Grants Committee, I just wanted to state that I think we took into account their location in considering impact and did not do it on a statewide level. And maybe we should have, but that's not how it was defined. So thank you for your time.
So Chris, why don't you run through anything else? And then I think we gotta
let's talk about the resolution. So the I'm going to this slide was just pointing out this slide was just pointing out the changes that we had made from the posted materials. So we talked about this. This is also in the posted materials. That staff proposes that the application track very similarly to the Hb2 competitive grant application for consistency. So it'll have a project profile, description, budget, and program assurances. Staff wanted to just flag for the HB Funds Committee that because these are supported by federal dollars, the reporting is a little different. We would try and keep it the same for HP1 and HP2 grants as much as we could, but the frequency of reporting might be higher such that programs actually have to file quarterly reports. And because they're federal dollars, it will trigger a single audit if the recipient would be spending $750,000 or more of federal dollars in a single year. Dwan, we had a couple of social consideration points. Do you want to cover these or should we go to the resolution?
Why don't we cover this so that everybody's comfortable also with this approach?
Okay, so one was we talked about whether or not the committee might support a 2-week shift, and actually it's a 3-week shift. I forgot to update this slide to accommodate a convening for programs. The staff wanted to point out that in response to a question from a program, that in the past the commission has approved homeless HP1 and HP2 grants for commercial tenant defense and landlord-tenant eviction, landlord-tenant disputes like eviction proceedings, with the argument that the services to the low-income commercial tenant, like the low-income business owner, supports their economic stability, which has been a clause in the authorizing statute. And so the question came up again this year: will commercial tenant defense for low-income business owners still qualify? And staff proposes to be consistent that they continue to qualify under the economic income stability clause. So if that raised any concerns with the committee, we just wanted to raise that we had done that in the past and we would propose to allow it again. And then the last one is some grantees have asked if they can have flexibility in budgeting different amounts for each year of the 3-year grants. This question has come up for both formula and competitive awards. And staff, Dwan, let me know if I'm missing a nuance, proposes that they do have flexibility to budget to spend different amounts each year, provided that the program understands the State Bar will be making 3 equal payments each year. Did I miss anything, Dwan, that you wanted to add to this? Okay.
But can I just, before you go on to that, can I just ask a logistical question about the convening? So I think we understood that the committee does not want the staff to kind of spearhead the convening, but would you be opposed? We partnered with LAC and LAC can spearhead it, but we are a partner with LAC because we do want to be involved in some capacity and not just informally.
Can you articulate why that's important, Juan? Like the formal partnership piece? Because actually,
I mean, we want to shape kind of what the panelists and what projects get featured. We want to have input, and we want to get the recognition for having the input and doing the work as well, just to be blunt with you. Do you feel it's a conflict of interest? I think that's what I was hearing, that you feel like it's aligned, because then that's privileging.
Well, I guess 2 things come to my mind on that. The first is that to the extent that the bar has a formal role, I do think that that ends up making it more difficult for the message to be prescriptive. So I do have concern about that. I mean, I have no doubt that LAC will take whatever you'll give them because you have expertise and hours to spend. And in terms of, if anything, I guess what I was hearing the committee say is like, we actually don't want you at the state bar to be spending a ton of time on this. But I hear your counterpoint is we think it would be productive to spend some time on this in order to shape what comes out of it. And I guess, you know, I'd be interested in your thoughts here, because in terms of credit, I think you're going to get credit for how this turns out. And I think you're going to, the state bar's opinion matters too much in terms of what people will ultimately do. But I think a formal role is part of the problem that I see. I don't think it's a conflict of interest necessarily. I just think makes it difficult to say, like, you know, this is a prescription for the kind of application you want to see.
So I guess that's a piece where I feel like, and maybe it's just me, and I'm curious to hear Bonnie and what LAC think too, but having the state bar, and this is not like staff getting credit, but the state bar and the commission, having like that formality gives it that seal of approval, but that we all are behind this and encouraging this partnership too.
Tell me if you believe that won't be the message that is internalized by the people who participate in the convening. I mean, I don't know how they could believe otherwise, because the messaging is going to be, look, we just came, we're hot off this meeting with state bar and commission members and the committee members. They're all like vociferously in support of these partnerships. I don't know, I'm not seeing how there would be a break in that messaging. But go ahead, Kim Bonachet, go ahead.
What I think I might be hearing from Dwan is that it is important to convey to the legislature that the state bar has involvement in whatever we want to call this meeting. Mm-hmm. And it seems to me that there's a way to do that in terms of maybe the kind of explaining the process, you know, kind of as technical information, and then essentially disappearing from the meeting, but also on whatever promotional materials, for lack of a better phrase, goes out, that there's an indication about the state bar being a partner in providing information. And then the state bar just sort of disappearing after the initial introduction.
Go ahead, Bonachet.
Kim basically stole the thunder. That's really what I was looking at. That's what I was going to point to, is that I think that's where Dwan is speaking from. I'm pausing because I'm thinking through, how can we do this? And I do believe the state bar should have some role, because the legislature, as Jim also pointed out, wants that. And we believe in it as well. So the question is just, how can we balance the interests? You know, what you're speaking to, Christian, the staff time, and Claire is, you know, I think making a good point here in the chat as well, that without our being present, there might be some questions that state bar staff could answer to. So maybe, what do you guys need a resolution passed today, correct?
We don't need a resolution on that. I honestly, frankly, I didn't think it was controversial, so we didn't put forth a resolution for the convening. But obviously, you know, we defer to you and what you think is the most appropriate. We don't have to take a big role, but what I would suggest is perhaps Chris and I or Christian and I can do like a short presentation at the beginning in terms of what's qualifying. I mean, it's not just for our IALTA community. We're envisioning inviting other stakeholders and community-based organizations so that, you know, there is a presence from the commission and the state bar. We can let LAC and Judicial Council kind of drive substantively. Chris and I can provide feedback behind the scenes, but that other substantive portion, we can let LAC drive it. I just think it's important for us to have a presence there and also to field questions.
So I'm
give legitimacy to the fact. I mean, obviously the community definitely defers to LAC, but it would be a nice show of support to have our presence, I think.
To be clear, Dwana, I'm not suggesting that the State Bar be uninvolved in it. I'm suggesting that the State Bar can't host it. So being a panelist is different than being the facilitator, or being a panelist or an attendee with a role on a panel to provide technical expertise. Comments will give the bar an opportunity to shape it. But I think it's different than the bar stepping forward as the host or as the facilitator of the convening, because at that point, I just think there's less of an opportunity for prescription. Go ahead, Bonnie.
Well, I will say, as the person this was my idea, as a way to help address the concerns that were being raised last week. I do think that the bar needs to have some sort of presence. I'm not sure, you know, what that needs to be. Yeah, and I just think we've got, you know, some really interesting competing requirements, right, between federal requirements and interest in the legislature, and we're all going to have to balance a fair number of things. But I do think that it's, I think Claire raises the points of people are much more likely to come if there's, you know, an indication that the state bar is involved, and there's, you know, sort of a level of credibility associated with it. So I don't know that that has to be determined at this point. I just think that there needs to be some role.
Does that, Dwan, is that sufficient guidance?
Yeah, I think that gives us enough. And Christian, maybe we'll just loop back with you then.
Okay.
Oh, fine. Yeah.
So I think we have to get to a resolution, and we also need to finalize the rubric itself today, do we not?
Yeah, staff would like to include the scoring rubric in the RFP that posts tomorrow. So we would like the committee, ask the committee to vote on the resolution or the rubric. I'm just switching over to share my screen in PowerPoint so that you can see me editing the slide instead of presenting it. And I'll still try and make this as big as possible for you. So hopefully, this is just so you can see me editing it live, but hopefully it's still big enough to read. I'm going to read out loud what we had originally crafted for you, and then I'm going to make a couple of changes that I think reflect today's discussion. So it reads, resolved that the Legal Services Trust Fund Commission Homelessness Prevention Funds Committee, acting on behalf of the Commission under its delegated authority, approves the priorities rubric and distribution plan for 2022 through 2024 HP competitive grants as described in staff's August 31, 2021 memo with the following changes. So we'd originally anticipated that the committee would support that the request for proposals would specify, this would be a change to the memo, will specify that partnerships are encouraged and that non-IALTA partners, including government programs, can qualify as subgrantees. That was reflecting the feedback that the legislature had communicated in the last week. That the RFP will specify that underserved immigrant communities are an example of particularly underserved communities. That didn't really come up in today's conversation, but that was also a suggestion that we had received, and I'll defer to others whether or not we want to include that. And that the scoring rubric will specify that partnerships is relevant to organizational capacity. And I think I actually heard that maybe we want to leave it there, but change the wording of it. I'm going to copy and paste because I was drafting This is going to make it look really long, but I was actually drafting the other edits as people were talking about them in kind of like resolution language. So let me put these in and we can talk about these and see if we want to wordsmith it or take any out. And I realize it doesn't all fit on the screen very well, so I'll just scroll so you can see them. Let's see, make sure everything is 20. Okay, so one that I just added was change the points available for project impact and strategies. This is, I think, Jim's point, to 25 points for exceeds, 20 points for meets, 15 points for below, 0 points for not addressed. And that was to facilitate moving 5 of the points to special consideration. So the next one is the corollary. Change special consideration to be worth a maximum of 10 points. I also heard specify that special consideration points are available for advocacy strategies rather than for litigation strategies. And then there was a suggestion from Christian, change the points available for focus on rural populations to 10 points for meets, 0 points for not addressed, without points for exceeds or below. So that would be like a 0 or 10 point binary. It would be not addressed or meets. But keeping the word meets allows it to sort of live in the rubric. It would like gray out the boxes for exceeds or below, I think, for that. Is there anything I missed or mischaracterized?
It would then no longer add up to 100, right?
Oh, that's right. So yeah, so if we did this, because the maximum for rural was 15 and now it's out of 10, it would be an additional 5 points we could put somewhere else. I think now it sums to 95.
The one thing I would correct, Chris, is the second bullet point there is that I think it would be, unless I heard your objection about this, the scoring rubric will specify that partners rather than partnerships may be considered with respect to organizational capacity. So in other words, we aren't crediting people for the partnership. We are acknowledging that the capacity of the partner is relevant to the capacity that's being considered. And then to Kim's point, the partnership itself could be called out in the special consideration. Those are the two differences that I see based on what everybody said. And then I think the last thing I'd say is, I said 10 points for rural, but others may have different opinions about that. So go ahead, Eric, Kim, Herman.
Yeah, so on that point that you're editing right now, I thought what Jim was trying to tell us is that it was, maybe we should add the word demonstrated advocacy strategies or proven advocacy strategies. Jim, I thought that's what you were saying, that the OMB wants us to focus on demonstrably proven strategies or something.
Evidence-based, I think.
Yeah, that's a term of art, evidence-based research.
And the other thing is, we didn't talk at all about the underserved immigrant communities or an example of underserved communities. I mean, why are we, I guess I see the argument for it, but there could be many other examples as well. Why do we want to call that out particularly?
Yeah, so I regret that staff, and that would be me, didn't make a point of this earlier in the presentation, that staff had received feedback from legislature that providing that as an example might be helpful, but Bonnie and Dwan, I don't know how important it is that we incorporate that feedback into the RFP. Is that something we want the committee seriously to consider?
We tinkered with it. The legislature wanted us to give an example, and we tinkered some with the language. So I guess at this point it might not be necessary anymore, right, Bonnie? We just take that out.
Yeah, I think that this is, if we're going to address it, this is the best way to handle it.
Well, we can consider that when we actually do the rubric, but to actually call it out as an example, there may be other examples as well. Why are we necessarily focusing on that one here.
Because we were told to call it out a little bit, I guess, to be blunt with you, but we tinkered with the language. So if you don't feel comfortable with it, we will take it out. So let's just take it out then, Chris.
That. And then I heard that Christian, it'd be okay to make sure it still sums to 100. And this would also keep rural worth the same number of points as underserved. It would be worth 15 points versus 0 points. And then that keeps us at 100 points total. Did I miss anything?
Herman, you're going to make my point, so go ahead. And then
well, my comment, all the discussion we had about rural, it appears that that it's important that rural receives an excess of points so that we can give more money to the rural community, because I'll make my same argument that if an LA-based program or a San Francisco-based program or a Sacramento-based program or an Oakland-based program does not reach out to the rural community, they are not going to get that 15 points. So even if they go to their maximum capacity in receiving points from those of us who evaluate, the highest they could possibly get is 85. Knowing that they will probably receive some less points in other categories, regardless of how good they are, they may end up with a 75 to an 80 score, which would not put them in a good place to receive funding if we do what we did last time, is put people into 3 or 4 categories, and people who didn't reach a certain number, a certain point, did not get considered. So if we're going to give rural 15 points, let us say to the community that the legislators want these monies to go to the rural community. Therefore, we're giving 15 points to those of you who are serving the rural community, and those of you in urban areas who do not serve rural community are at a disadvantage in regards to the distribution of points.
Herman, you're acting like the legislature favored rural over special populations. And it seems to me in the language, those are treated the same. So it's just like if you're considering vets, you're more important than if you don't consider vets. I mean, if you're going to have that language, the language ought to be the legislature prefers projects that serve special populations and or rural populations.
Well, what we're doing in the points, Jim, what we're saying is that if an agency does not indicate that they serve rural population, the highest possible total points they can get is 85.
Yeah, and if a rural program doesn't single out a special population that they're serving other than rural, the highest they could get is 85.
But if anybody in the rural community is worth their salt, they will say we're serving the mentally ill, we're serving substance abusers, we're serving homeless, we're serving immigrants. Therefore, they get that point total. If I'm an urban program, I can't say that I'm doing rural for the most part. So I'm at a disadvantage. I can only get a maximum score of 85, meaning that I get all the points from all the other categories, which means when my point totals come in, I'm at a disadvantage.
But like I was saying before, if you have a rural program that's only serving a very small population, they're not going to get 85 from me because their impact is going to go down. They're going to lose 10 points on the impact issue, the very first category, because they're having no major impact because they're serving a small population.
Well, if you use that argument, then all the money should come to urban, it should come to LA because we're serving a big population.
No, because they're not serving any rural unless they're going out to Antelope Valley.
Anyway, I've exhausted my argument at this point. So,
well, for what it's worth, Herman, I'm persuaded. I think 15 is too much. I guess I don't think 15. I think 15 in our last round was a huge differentiator. And I just think it's too much personally. So I mean, I'm feeling like 10 is too much, to be honest, but I also don't feel married to 100 personally. I don't know why that's a magic number. Honestly.
Yeah. Should it be less than an underserved population?
Well, but I guess to her point though is that an underserved population is not a binary. A rural community is effectively a binary. If you are not operating in a rural community, the chances are very high that you are going to get a 0.
And if you're just serving the homeless and you're not specifying some special population, the homeless, you're not serving an underserved population.
Right, so then you're talking about basically an LA-based program that just has a general homelessness prevention whose maximum score is now going to be below what the watermark was the last time around, which also seems.
Gentlemen, I'm going to jump in here now.
Okay.
So 2 things. The first is on this issue of rural. I'm actually very uncomfortable that we are even discussing the potential of moving rural out of the importance and the focus of what we've been doing at this commission for years. We know that those communities do not have the same access. They do not have the same level of funding sources. They do not, there's so much they do not have. So to think about even this discussion that we would be potentially diminishing the very little that they do receive, that this really makes me uncomfortable. That's one. The second is the legislature has been clear. They want for us to distribute funds in these particular areas for everything that I said, plus much more. So I really want to discourage us from going down this line. The second is we took out the languaging about immigrant communities. And we said we don't need to call it out here, but have we called it out anywhere else? Does that language exist anywhere else?
It doesn't exist anywhere else.
It existed last year because the legislature, I think, specifically told us to focus on service to immigrants, but they took that out this year, I understand.
So Bonnie, it's taken out completely. We don't need to.
Because it is federal funding, there is sensitivity about how to describe that.
Got it. I got it. Okay, great. Those were my only 2 points. Thank you.
If I may speak, Bonnie, the only thing I would say to you about giving money to the rural community, which I think is necessary, let us be very clear in what we put out, and that saying that the legislator has said that they want monies to go to the rural community, and those of you that will provide service in the rural community stand a better chance than those who provide service in an urban environment. Let us be clear. Let us not try to hide it.
Well, Herman, we don't have to say that in the rubric. I mean, I think giving points to rural essentially says that.
That's exactly that, yes.
The only, just to, if it helps resolve this issue at all, staff proposed the rubric you saw before with rural and underserved broken out in different rows, weighted the same way, with exceeds, meets, and below and not addressed, because staff finds that it can fit proposals into those 4 categories. And as a reminder, the commission and committee decided to that the committee would calibrate 3 to 5 applications to the rubric, and then staff would score. So I just wanted to say, from staff's perspective, staff feels confident that it can score to the rubric that staff proposed, if that helps at all. This is not to invalidate all the amazing points everyone has made, but if it helps to work towards a resolution.
But I'll just ask the question. So if I'm in LA based on an urban based program, I'm not serving rural, and 100 points is the maximum total, the maximum I can get if I meet all the other criteria, is 85.
Right.
Okay, that's all.
Yeah.
This is Rich. I've got my hand raised, Chris. If I'm out of order, I'm happy to back off. But
no, I was calling you, but I was on mute.
Okay. But I want to make a counterpoint to that, Herman. If you're a rural program with no underserved community or urban service, then the maximum you can score is 85. What the rubric does now is bias us in favor of programs that serve both.
Richard, if I may respond, if I'm a rural program, if I'm serving the homeless, if I'm serving the mentally ill, if I'm serving an immigrant population, if I'm serving a substance abuse population, I'm serving an underserved population. Therefore, I will score in both categories.
I think what the impact section that Jim is talking about would enter into my thinking about that. And I would be inclined to say that someone located in a rural area isn't going to be serving the same population, and their impact is going to suffer as a result.
Well, I would just note that in that category of impacted strategies, you know, in order to account for that, you'd have to fall below expectations. So in any event, I think we need to entertain get the final universe here so that we can vote on this resolution. Other than Herman and me, is anybody else interested in lowering the points on rural from 15?
I'd support that, Chris.
I would just note that given that we have the ability to digress from or not digress, but to depart from the overall scoring in order to provide the privilege under the statute for rural communities, it would be easier to accomplish that if there was a little bit of a tighter band. But
what will we do with underserved though? If we reduce rural to 10, are you also going to reduce underserved to 10?
You would have to. You would have to. This doesn't, I mean, we don't have a vote on this yet, so I don't think we should right away move it to 10. I was just looking at who's left because Amin and Kim had to sign off. I think there are only 6 of us left for voting on this. Am I right?
2, 3, 4, 5, 6. Yeah. And quorum is 5. So.
I would be okay actually reducing that as well. I mean, I just think that the homeless population is by definition underserved in a way that it's going to emerge in most of these applications in some capacity.
I agree. I think underserved, as Kim pointed this out, is just so vague. I mean, everybody, I mean, I don't know what you do with that.
So that if we move in that direction, I think staff would ask that since we want to pair them, that the focus on underserved populations also be 10 or 0, or did you want to preserve the gradations?
Personally, I don't see them as being equivalents in quite the same way that I think Bonachet was expressing. So, because I just don't see them as being binary. I mean, we have an actual metric for what is rural. So I'm fine to maintain it as, you know, exceeds meets below.
So, yeah, I was just wondering because if we go down to 10, and the categories are otherwise 5 points apart, it would have to be like 10, 7.5, 5,
yeah.
2.5, 0 or something. Yeah, we have to have a different spread.
I would not advocate changing the unserved population. I think exceeds meets below is fine with 15 points, and I would propose putting rural at 10, which is going to give a bonus to those programs that are focusing on explicitly, or not even explicitly, but or exclusively rural populations. It's just going to be a yes or no, and that's going to bump them up 10 points.
Well, I still disagree. There's differences in terms of outreach and focus. It's not just a yes or no, or at least it wasn't the last round last year. Was it yes or no?
I agree, Jim. It wasn't last time.
I agree with Jim. I think it should be a gradation as well. I think there could be distinctions in the effectiveness of the organization's focus on rural. Some organizations may focus on it just a little bit, and some may focus on it very effectively.
The gradations can also take into account differences in the quality of the written proposal. So you might have a proposal that just does a very good job of explaining how that community will be reached. Maybe it's the quality of the proposal that exceeds the expectations.
Bonnie just typed into the chat the language of in awarding these grants, preference shall be given to qualified legal aid agencies that serve rural or underserved communities.
Mm-hmm.
But then do you take it out of the rubric and just have some kind of general preference that you layer on top of the score? Is that the proposal?
I'm not sure. Bonnie, are you able to jump in to this conversation?
Sorry, that I wasn't. William had asked what the statutory language was. I think if you don't include it in the rubric, I think you're not giving enough guidance to the programs personally.
So Duan, jump in here, Bonnie, jump in here if you disagree with this, but I think maybe having heard what the committee members have expressed so far, staff would propose, staff would stand by its original proposal of leaving it out of 15 points with the different exceeds meets below. But if we make rural out of 10 and it's a binary, take the 5 points, leave special consideration the way it is, and take the 5 points and give it back to project impact and strategies, because originally that was like out of 30 points instead of 25.
Or take them both down to, I mean, I think the difficulty from my perspective is, again, how do you, underserved is such a hard not to have a population that's underserved. So you could make them both 10 and give more points to but anyway.
Yeah.
It feels a little weird. I mean, I take Christian's point about it being binary, but it does seem to give additional credence to underserved.
10, 5, 3, and still have a maximum of 10, something like that.
I mean, it being a binary, it's still going to be like, it'll be very easy for a proposal that would focus on as Jim pointed out, like an MSSA medical service study area county, or it's not, they're not county tracks, but census tract. They would get 10 points that to Herman's point, no one else who'd focus on an urban area, suburban area would get. So they would be getting preference. Like, and 10 points is nothing to scoff at. And I think you could leave special consideration out of 15, or I'm sorry, particularly underserved out of 15, because it invites a gradation.
But that suggests underserved is preferred over rural.
That's right.
Yeah.
And the legislature didn't say that.
Exactly. I think they need to, whatever the number is we're giving to rural is the number we should be giving to underserved.
Yeah, I agree.
So I think what staff is hearing then is the points available for underserved will also be out of 10 points, and we can find, take the 10 points, the 5 that we took from focus on rural and the 5 that we took from focus on underserved, and take those 10 points and give them to another category, or split them between special consideration and project impact and strategies.
Chris, is this too much work if you quickly put it into the rubric right now so we see it?
Let me see how easy that is.
I know we're 40 minutes over time, so if it's too much work, let's not. But
I mean, it might require some like reformatting of the table.
Okay, no, that's okay. That's fine.
Okay. I'm certainly happy to give it a shot. But
so, are we talking about a gradation or binary for the 10 points?
It's binary is what we're discussing. But so we've got 10 points extra. Could we put 5 and 5, 5 into organizational capacity and 5 into project impact and strategies?
I would put it in special consideration.
Yeah, I was thinking the same thing, special consideration. Or is that too much? That would make it 20.
It's a very broad area.
Or split it, maybe another 10 in special. It's 10, right? Then we need to distribute.
That's right.
Mm-hmm.
Maybe 5 in special consideration and 5 in project impact.
Why are we so wedded to 100 points? I don't really track that.
I think we were deferring to Jim. Jim had a really good reason why, because we had it under a different scale before, and Jim convinced us 100 was easier.
Why, Jim?
Yeah, well, most people are generally look at it in terms of percentages and 100 points. I mean, we all grew up that being graded in everything from elementary school up through high school and college. People have a better way of handling that than say like 105 points or 95 points. And juggling the point weights around is not that difficult to reach 100 points.
So on rural and underserved, it seems to me if we're going to do binary or gradation, we should do the same for both.
Yes, and I would argue for gradation.
Yeah, I at this point, I feel, I'm just going to say, I think I've lost the fight. I think Herman has lost the fight. And I think we should just make these changes, leave it at its 15 points. And I think take the vote and do that. I have some predictions about outcomes, but you know, when the time comes for Herman to say he told you so, I'm sure he'll have the mic to do that. So I think go with the gradations. That seems to be the will, and I don't think we've come off of that.
It could be 10 points, Chris. You know,
but I don't know how you do that to 3, 5, and 10 or something like that.
Mm-hmm.
Yeah.
Or you could make a below and not address both with 0 or something.
I mean, yeah. Well, I feel we're belaboring these things.
Yeah, I just actually want to make a point that you guys, I'm actually 42 minutes behind schedule. I know we all are, and I have to jump off, and I understand I need to stay on for quorum. So let's just decide what we're going to do.
Yeah, that's why I'm saying let's go with the staff proposal with the couple of the clarifications there. Leave it at 15, and then chips are going to fall where they fall.
So the motion is, sorry if I've missed it, the motion is staff's proposal, which was both out of 15, both gradations.
Well, you leave the special consideration, but it's just the underserved and the rural, I think is.
Right, we're gonna leave underserved and rural the way staff had proposed it.
Mm-hmm.
Okay. I'm going to delete.
But I think you still need to tweak points, right? Because we're adding the special consideration for, will we bump that up to 10?
We already got that. It's
okay.
Special consider. So the motion now is the points available for project impact and strategies will be out of 25.
Okay.
That had freed up 5 points.
Gotcha. Okay.
And so we gave it to special consideration, so it'll be worth 10. And then special consideration points will be available for partnerships and evidence-based advocacy strategies rather than for litigation strategies.
Okay.
All right. Did I accidentally delete something we wanted to keep? Okay. So actually, I don't know if Christian, you were making the motion or not, but
yeah, let's do it. I'll move.
I'm pulling up my roll call or my tally sheet.
I'll second.
Thank you, Eric. So Christian moved, Eric seconded, and I'll call the vote. So Christian.
Yeah.
Bonachet?
Yes.
Amin is absent, I believe. Herman?
No.
Eric?
Yes.
Jim?
Yes.
Rich?
Yes.
Kim?
She had to go off.
Yeah, she had to step down.
So the motion carries. So thank you, deeply for staying so long to make sure that this was a thoughtful process. So yeah, and staff was able to accomplish what we hoped the committee would be able to accomplish today.
Thank you all for all the hard work.
So it did warrant the time, I think. That's my view.
Well, we have one more item on the agenda. I think we're not going to get to it.
Oh, it was the last one was discuss any other questions that might have come up. We wanted to catch all item on the agenda in case a program had asked a question about the formula grants, but actually nothing came up. So this was our staff's final business item.
Okay. Well, thanks everybody for staying late and for the discussion. And I think that wraps it, Chris. Duan, yeah?
Yes, thank you everyone very much for staying.
Thank you so much for staying late. Yeah.
Thank you, everybody.
Wish you a
good evening. Okay. Bye-bye.
Bye now.
All right. Take care, everybody.